Welcome to another episode of the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca, your trusted source for family and divorce law insights in Ontario, Canada. I'm Deepa Taylor. Today, we're diving into an essential topic that intersects family law and real estate in collaborative family law. Whether you're contemplating a separation, navigating the complexities of a marital breakdown, or are a professional working with clients in these situations, this episode is packed with vital information you won't want to miss. In this episode, we'll explore the critical aspects of handling real estate within the collaborative family law process, covering everything from the valuation of matrimonial homes, the implications of joint tenancies, to understanding how to protect your assets and rights during a separation. We'll also address common questions such as, can I change the locks? Or, how should carrying costs be handled if one spouse vacates the home? By the end of this episode, you'll have a clearer understanding of how to navigate these challenges within the collaborative process and protect your interests. Let's start with an overview of collaborative family law, especially in the context of real estate. Collaborative family law is a voluntary dispute resolution process designed for separating spouses who want to avoid the adversarial nature of court proceedings. This process focuses on negotiation and reaching a mutually acceptable separation agreement. It's not just the lawyers involved. Typically, a collaborative team includes neutral professionals, like a family professional who can assist with emotional issues, and a financial professional who helps with financial disclosures and valuations. So, what does this mean for real estate? In a collaborative process, the handling of real estate is both flexible and client-centered. For example, if you and your spouse own a matrimonial home, the collaborative process allows you to work together to decide on its future, whether that's selling the property, one spouse buying out the other, or some other arrangement. The key here is that the outcome is controlled by both parties, with the assistance of their collaborative team, rather than having a decision imposed by a court. One of the first hurdles you'll encounter is determining the value of your home. The process of valuing a matrimonial home in a collaborative law setting can vary depending on whether both parties agree on a value. Ideally, if you're working with the same real estate agent who originally helped you buy the home, there's already a level of trust. However, if you can't agree on a value, the next step might be obtaining a letter of opinion from a real estate agent. If further assurance is needed, you can jointly retain a certified appraiser who provides an impartial valuation that both parties can agree on. It's also essential to remember that in collaborative law, the valuation process is more than just about numbers. It's about reaching a fair agreement that both parties can live with, which is often achieved through interest-based negotiations. This can include discussions about whether to sever joint tenancy, particularly if one spouse wants to ensure their share of the property is passed to their beneficiaries rather than automatically to the other spouse in the event of their death. Next, let's delve into some specific real estate considerations. For instance, you might be wondering, should I sever joint tenancy on our home? Or, how do I protect my right to a date of marriage deduction on real estate owned before the marriage? These are crucial questions. Severing joint tenancy is often considered to protect individual interests, especially in scenarios involving estate planning or protecting assets from creditors. It's a decision that should be carefully weighed, often with the guidance of your real estate lawyer. Another critical aspect is the date of marriage deduction, which can significantly impact the division of property. If you owned real estate before getting married, it's wise to think about documenting its value at the time of marriage. This can be done through a real estate appraisal or obtaining a market comparison from a real estate agent. Such documentation is vital in protecting your interests during the property division process. Let's move on to some of the common real estate issues that arise during a divorce, especially within the collaborative process. One frequent question is, who is responsible for carrying the expenses of the home if one spouse vacates? In most cases, the collaborative process encourages maintaining the status quo, which means continuing to split the mortgage, taxes, and insurance equally until the property is sold, or one party buys out the other. The spouse remaining in the home would typically handle the utility and maintenance costs. Another hot topic is changing the locks. Legally, if you're married and the home is considered the matrimonial home, neither spouse can change the locks without the other's consent, unless there is a court order or written agreement stating otherwise. However, for common law spouses, the situation can be more straightforward, with the legal owner usually having the right to change the locks, though it's always best to consult with a lawyer first. Now, what if you and your spouse can't agree on whether to accept an offer on your home? This is a situation where the collaborative process can really shine. The collaborative team, including your real estate agent, can work together to provide expert advice and help mediate the dispute. If all else fails, you might need to involve the courts, but the collaborative approach is designed to minimize the likelihood of this by encouraging cooperation and compromise. Another scenario that can cause delays is when one spouse is dragging their feet on selling the home. Here, a family professional can be invaluable in addressing the underlying emotional issues that may be causing the reluctance. By facilitating open communication and understanding, the process can move forward more smoothly. Finally, let's talk about some creative solutions within the collaborative process. Suppose a client has already purchased a new home and needs to finalize the sale of the matrimonial home quickly. In this case, the collaborative process can be highly flexible, allowing for tailored agreements that expedite the sale. This could involve bridging financing or negotiating a spousal support buyout to free up funds needed for the new purchase. Moreover, the collaborative process allows for creativity in financial arrangements. For example, if spousal support obligations are affecting your ability to secure a mortgage for a new home, the team might explore options like a lump sum spousal support payment or adjusting the division of other assets to facilitate the financing. Real estate is often one of the most significant assets in a marriage, and how it's handled during a separation can have long-lasting implications. The collaborative family law process offers a way to address these challenges in a cooperative, flexible, and client-centered manner, reducing the stress and expense often associated with traditional litigation. I hope today's episode has provided you with valuable insights into the role of real estate in collaborative family law. If you're navigating these waters or know someone who is, I encourage you to reach out to a collaborative law professional for guidance. For personalized guidance, please consult one of our family lawyers by visiting DivorceLawyers.ca. Thank you for joining me today on the Divorce Lawyers podcast. Don't forget to subscribe and leave a review if you found this episode helpful. For more resources and information, visit DivorceLawyers.ca. Until next time, take care and stay informed.